the opportunity for the patient, or if they do not have the capacity to have that conversation, that informed conversation, their authorized representative. We can get into the sort of, in Georgia, the hierarchy, because there is a hierarchy as it relates to that. And so, here we go. Yeah, okay, thank you. Yeah, and Dr. Rosenquist touched on most of these points. I am not gonna, but these are the requirements in Georgia. We talked about diagnosis, nature and purpose, material risks, the likelihood of success, what alternatives if the patient were not to go forward with this treatment, and what is the reasonable prognosis? What is the reasonable outcome if we can say so? So you notice up here it doesn't say form, it doesn't say that you have to have an informed consent form completed. However, we certainly want that. That's the ideal situation, because what is the form really? It's documentation that this conversation did actually take place. And so in Georgia, if you have a consent form that is completed, and they use some legal words that conform substantially to what the Georgia law requires. If there were a claim by a patient or a patient's family member or what have you says, there was not proper consent there, if the consent is completed, we have a legal presumption in which the plaintiff, in this case, would have to overcome, which it's in litigation, having to sort of poke a hole in that, overcoming that presumption. It's oftentimes a difficult thing to do. So it does provide that protection for the physician or any clinician that might be involved or named in a lawsuit as it relates to consent. But no matter who, the physician, Dr. Rosenquist, might ask, one of you nurses to go and talk to the patient, or it's a team kind of discussion about the consent. That legal responsibility remains on that physician. So whether Dr. Rosenquist has a resident go out there, there is some reliance and there needs to be some trust on his residents, but that legal responsibility doesn't shift to a nurse, it doesn't shift to anyone else. So you'll hear me preach. I want the physicians. I think the physicians should be involved in the discussion and not turf it, to someone else. And so definitely, obviously, that's not happening here. But y'all know, y'all are in it. Some of you all have to oftentimes go in there and consent the patient. But just know that legal responsibility does not shift to anyone but that physician. So if they're comfortable with that process, that they're trusting somebody, then they're signing their name to it. And so, did you have a question?
Yeah. So even a PA, right? Can an FNP?
It depends on the procedure. So if it's a procedure that a PA can do individually, that they're allowed to, and I don't think there are too many cases of those types of procedures, but I'm struggling to come up with one off the top of my head. But maybe you have one.
Thompson, Stephen Thompson, he'll sign sometimes on he's the cardiothoracic, right?
I think that there is something that they can do, like the block team, some of the nurses work on that.
Good point. Yeah, so I guess it boils down to if it's a procedure that this individual, the non-physician, is authorized to do without direct supervision, then yes. Then in those cases, that particular individual licensed provider would have that responsibility.
Can I say something really quickly?
Sure.
So you all know we do have a program in Aiken, South Carolina. It's a little bit differently arranged, where we have a single ECT nurse who kind of handles all of the pre-authorizations, et cetera. And she actually goes to the patients with our consent form, goes through everything with them, gives them an opportunity to sign. I come in when I'm there and say, did you understand what it was? Let's go over what you've done. I sign it too, but in this case, the nurse isn't obtaining the consent, but she's participating in the consent process by providing information, and it often gives me a head start into the process then. So I wouldn't be opposed. I'm not opposed to a system that works like that. The way we've been doing it is documented through the consent form. I'm happy to have it continue in the way that it is, but I just want to let you know that there are places where nurses have a somewhat greater role in the provision of information related to these.
Yeah, and let me be clear. Make no mistake. I'm not saying that that's not a good thing necessarily, that a physician has other people like you all assist in that process, because many times you all are more seasoned, more experienced with dealing with a lot of these issues, perhaps than maybe that physician is. And so, the law provides that non-physicians obviously can assist. It's just that legal responsibility remains on that individual physician. And so, if we get to the case, if we get to the scenario where the patient is unable to consent for themselves, or we don't feel that, when we're talking to somebody that we know, maybe because you all know the capacity, someone may have appear to have better capacity on one day versus another, and maybe it's gotten to the point where not comfortable with this person being able to consent for themselves. So, in Georgia, who would you go to next? So. We've talked about, I heard Dr. Rosenquist talk about, if it's an emergent situation where clearly this patient needs it, they may have some organ system that might be failing, or possible death. I don't know if it's a scenario when you might need it if you were going to die, but if it was an emergency, then we would not even have to go to all these other people. We would obviously document thoroughly that why we believe this is an emergent situation, and we could Georgia allows for implied consent for those purposes.
Yeah, two situations I think of that most of ECT. One is catatonia, where they may have elevated CPK. I wouldn't hesitate to go ahead and treat under those circumstances. The other would be neuroleptic malignant syndrome, and finally probably the status epilepticus we've done up with neurology. So.
But the point being, I think in those cases, the documentation needs to be there to support what you're doing. That it's so dire that we don't have time to look for these other individuals. So if it's not an emergency, though, we look then. Is there some legal document? It says advance directive up there, but we hear power of attorney all the time. I'm so and so's power of attorney. To me, that's it's an immediate question after that follow. Okay, well let's see the document, because no one is born or wakes up one day and becomes someone's power of attorney. There's some legal document out there that named that individual to be the power of attorney. So most of the time, I would say there's a good faith obligation on us to, if someone says this is I'm so and so, this is my spouse here. We don't then say, well, let me see your marriage license or something. We don't. The law doesn't obligate you all. We want y'all to take care of patients. We don't want y'all having to deal with that. But if you have the scenario where someone says so and so is my wife, and then somebody else comes in the room and says no, I'm the spouse, then you're kind of like, all right, time out. Now we need some legal documentation. Say, who the heck is the legal spouse here? But for y'all's purposes, just ask for it. And you've got a legal office 24/7. We can, you can hit me up at any time. We'll, review such documents to see, what, as best we can, is it a valid document? So if there's no legal paperwork, then we're kind of getting into the next of kin, which a lot of people say, yes, ma'am.
For the power of attorney, though, it has to be a medical, not a general, correct?
That's a great question, because there are power of attorney. Those documents come in all sorts, shapes and sizes. So it would need to specify that the power of attorney did grant the authority to make medical decisions. You wouldn't, some people try to bring in a financial power of attorney and say, oh, see, I can make medical decisions. And if it's silent on that, I would not be comfortable advising you all to rely on that, unless we had no one else, and we had demonstrated that we looked, made a good faith effort to look for other people. So that's a good question. Yeah, power of attorney, I would just get a copy of it and send it to me or Clark or Madeline in our office. But if you have no legal document, or someone can't produce it, for instance, then what do we do? So in Georgia, here's the hierarchy. So we're going to ask, is that person married? All right, and Georgia doesn't recognize common law marriage anymore. They did pre-1997, I think. So, if someone says, yeah, we're married, and we might want to clarify, are you the legal spouse? And if they tell you yes, then I think we're good. Unless there's some other circumstances we don't know about, like the example I gave, where someone else comes in and says, oh, I'm the legal spouse, then I think you can go with that. Similarly, if there's no spouse, we then go in Georgia, adult children. And the key word here is any adult child, because a lot of people misunderstand, and there are differing laws around the country. But in Georgia, if we pick up the phone and the person on the other end is the baby adult child, we can go with that. Similarly, not everybody has to agree in Georgia. Now, we'd love for all the family to be on board with us and support what we're doing, but just from a legal standpoint, we can go with one adult child saying, yes, I agree, this is best for mom or dad, and we can have the other people saying, no, we don't want that. Now, I mean, I think we need to tread carefully there and try to understand as best we know why the other children are not thinking this is in the best interest of mom or dad, but just to put it to you simply, we just need one adult child, and we just need one sibling. I skipped parent because that if you have a minor child, there's some issues there where if just in terms of specifically maybe end of life issues where Georgia law does provide that both parents need to be notified if they're going to withdraw treatment. Hopefully, you all won't be having to deal with that, but I did want to throw that in there. One other thing that comes up a lot, we get questions about, well, so and so's married, but they're estranged, or the family doesn't talk to, the children are estranged from their parent. Estrangement in Georgia doesn't affect any of this, and so a lot of people want to just bypass that person who is, quote, estranged, but there's really no legal foundation to support that on, and so you need to be careful when somebody starts talking about whether they're estranged. We really, this is the process, this is the order that we need to go in. And again, we're just assuming there's no advance directive or legal document telling us otherwise. These are all the if we don't have them. So you'll see where we go after siblings. It goes to grandparents, grandchildren, niece, nephew. We get questions about adopted children or relatives. If it's a legal adoption, that is just as good or just as important, so to speak, as a blood relative. So don't get tripped up there. The adult friend's always a difficult one. But Georgia has sort of a catch-off. We get through the family members, we can't find anyone. Georgia also allows for an adult friend to consent for someone. And then this person, yes, they need to be literally an adult and I guess a friend, but if you take, for example, someone who is choosing not to get married, they're with a person you're dating or whatever, a partner or something like that, and they don't get legally married, or they don't name them as their power of attorney or healthcare agent in a advance directive, this is where that person's going to be. And so you may have someone that two people living together, you got an incapacitated patient, you've got their boyfriend, girlfriend, or partner of X umpteen years, and there's no legal document, there's no legal marriage. All the other family members who are estranged, they actually have priority, and that's very hard for us to see, because wait a minute, these people know each other, they love each other, they should be able to, right? Well, actually no. If they don't make specific, if they don't make specific thoughts about it, then they're kind of at the bottom here. But other examples of that, aside from outside of romantic relationship, it could be a neighbor, could be a pastor or somebody from their church goes and visits the person. It's just got to be someone that knows the patient and is generally familiar with how they would want their medical treatment to go. If we don't have any of these, then we have to take the position that we have to probably go to a probate court and say, Judge, we need a guardian appointed here. It's going to be very time consuming, expensive, and it's not usually going to be in the best interest of the patient. So to the extent we can find a family member or otherwise, it's really going to be more ideal. So any questions on those? I mean, these types of things, y'all don't need to remember this. Y'all don't need to print it out. I mean, it might be helpful. I mean, y'all can call us anytime. We get consent questions quite a bit. Trying to think of some other things we talked about. Dr. Rosenquist talked a lot about capacity, and people confuse it with saying, oh, so-and-so is competent or they're incompetent. Well, I'm thinking, well, what does that mean? Did a judge say that, adjudicate that this person's legally incompetent? Okay, maybe. It seems it's pretty rare, I guess. And again, we need documentation to support that. The other one, sometimes there are legal incompetencies. So, for instance, until you reach the age of 18 in Georgia, unless it's for a pregnant minor or a minor who's married or who has been specifically named as emancipated, people like to, that one seems to come up a lot of times too. And so if none of those things and none of those exceptions apply, then a minor child can't consent for their medical treatment. So that would be an example of a legal incompetency. They're legally incompetent. Georgia passed a law to say we don't want 15-year-olds entering into contracts or being able to make medical decisions for themselves. And so, I think we could have a good discussion long past that to see, well, I think certain 15-year-olds are more mature than others or what have you, but that's sort of how that goes. Prisoners, not that you all are questioning this, but I do hear it all the time. A lot of people, unfortunately, misunderstand. They think that because you are in a prison facility that you have you're not allowed to consent for your medical treatment, and you can just be forced to do whatever we want or the prison wants. That's not how it goes. A patient does not lose all. Now you lose some rights, obviously, being in a prison or a law enforcement facility like that. But in general, a patient, an adult patient who has capacity to make decisions can refuse or withdraw consent at any time. So again, don't be tripped up on things like that. So I don't know if there's any specific questions or things that we need to touch on, but I'd certainly be happy to do so.
The one variation I think we see here is kind of a capacity that's variable, right? So that when they're in my office the very first time, maybe like, yeah, absolutely, that's what I want, or the opposite, right? They don't have capacity when they start, so we get a substituted consent. But then they get some ECT and they're actually getting better, and so it's time for their new consent. Well, the last time they got it from their mom. We have a gentleman that we've been treating, Mr. C, who started off, he was in the ICU, intubated, and we gave him ECT to get him out of the mental state that he was in there. Now he's at the stage where he's actually, he can be manic, right? He can be pretty ill, but he's also, compared to when we started, his capacity is much greater, and so when time came for him to have his next consent, we had that conversation, and yeah, I want you to go ahead and do that. I understand this is helping me. There's an interesting sort of dynamic. I was talking about this balancing act with how much information is enough information, right? And a couple of things influence how I view that, at least, and how most clinicians view this, is if the risk of the procedure is very high, the standard for the amount of information goes up, right? That makes sense. If it's a less risky thing, then I'm not going to be as much of a stickler about you have to understand every element of this idea. How risky is ECT? Is it a high risk procedure?
Being on patient, yeah. It's a complete opinion on comorbidities.
Yeah, so there's general anesthesia. The brain's connected to the heart, so we get arrhythmias. All of the people who died from ECT, the risk of death is very low, 1 in 10,000 to 1 in 100,000. So for most people, it's not a very risky procedure. But at the same time, it has risks, and we need to convey those to the patient. The other sort of component of the, how much information is required relates to the severity of the illness, right? So that if I recognize this person is in a psychotic state, I'm not going to expect them to process all of this. But if they can process at the level of understanding, this is something that's going to help me, and yes, you're going to put electricity in my head. That's enough. I don't need them to be able to quote back to me all of the different side effects that are involved. So again, the main point being that as the risk goes up with the procedure, as the severity of the illness goes up or goes down, then the standards for more information. If the person is unlikely to benefit, we wouldn't be doing it anyway. So I just want to make that point before we close today.
I have a question. In the nursing world, we use like kind of orientation more so than we use capacity. Like if for us, how would you compare like being alert and oriented to time, place, situation, and balance that with capacity? Like as we're interviewing the patients and they're, in Las Vegas and I'm their Aunt Janie and like, and then how does that relate to capacity?
You want to take that one? That sounds like it's for you. But
Yeah, I go ahead, yeah.
yeah, so to me, cognition has many faces, right? There are many manifestations of your ability to use your brain for different things. Orientation is a pretty rudimentary one. I mean, for most of us, when you're thinking about what comes back first after ECT, right? First thing they can tell you is, like, who am I?
Right.
Yeah.
Then they can tell you, where am I? And it's not until later they can say, well, what day is it today?
Right.
Right? So if someone doesn't know what day it is today, I wouldn't try to hang a hat on that. I wouldn't say, oh, you're incapacitated because you don't know what day it is today.
Thank goodness, because I'm like,
I don't know what day it is today, but I know you're going to do ECT today.
Yeah.
The question mark about doing ECT is more important from the point of view of capacity, because capacity is about a specific decision. It's not about a general cognitive capability. Now, we do know that if you are, for example, when you gave where I'm not even oriented to person, right? I don't understand who you are, or I'm oriented to place. I don't know that this is a hospital. Kind of hard to say this person is understanding clearly what it is we're about to do, right? If they don't have that ability. Now, sometimes people may have an understanding, but they may lack the ability to communicate that, right? Their vocabulary is not such, or they have a stroke and they can't say it. And then you have other ways to get around it, like you can say, nod your head if.
right.
Did that answer your question, or was there more to it?
That did. I think that seems, from what I hear, that's the question. Like when we're doing our routine assessment, if they aren't oriented to those things, would it be best to have ready the next of kin's phone number if it's a consent day, so that we don't slow anything down and we don't have to go down too many rabbit holes, like and we can just keep moving. What would be the best way for us to handle that, to alert you?
I mean, you can just come and tell me.
Okay.
If you think there's been a change, you think that the patient is not really expressing themselves. I mean, whatever it may be.
Okay.
Orientation may be one thing, but it may be something else that's come up in the meantime, and that's helpful information. Come back and talk about it. I mean, the situation I want to avoid is one where we're kind of standing on principle. And so here's the treatment that we know helps this person,
Right.
but today we don't think we should give it to him. Another example which is very problematic, right? Let's talk about our young man